Right, without any further ado, I'm going to introduce our guest speaker. Bringing new people into your business, especially for the first time, may feel daunting, but it needn't be. Our guest speaker today is an experienced employment lawyer with practical HR experience. She works with all organizations of all sizes, ranging from small to medium to large multinational organizations and those operating in the charity and public sectors, helping them to bring on new staff and successfully manage the HR and employment law challenges that they face on a day-to-day basis. She is the founder of JMA HR Legal, and she's based in Bordon, which she set up in 2009, specializing in HR, employment law, and immigration. She is also a fully trained mental health first aider, reflecting her commitment to supporting employees and employers managing mental health issues in the workplace positively. In her spare time, which I doubt she has much of, bearing all of that in mind, she enjoys photography, keeping fit, travel, and the great outdoors. I am delighted to introduce to you today, Joanna Atkinson. Come on in, Joanna, come and join us.
Hi, Louise. Hi, thank you very much. Let me start my video as well.
Yeah, great. So thank you for joining us today. We're really excited to hear all about employment, HR, and how these small businesses can really grow and help their businesses by employment and helping people.
No, thank you very much, Louise and Gareth, and thanks for asking me to come and talk today and to BizHub generally. And it sounds like so much is happening at the moment, which is really reassuring, isn't it? Because we've had such a bizarre time.
We have.
The last, 18 months now. We talk about a year, but it's now 18 months, isn't it? So it's reassuring, isn't it, that business is flourishing and we're all getting out and about a bit more as well.
Definitely.
So
right. So we are going to, we're going to love and leave you now and hand over to you. We're in the wings if you need us, but yes, over to you and we'll see you shortly.
Great. So hopefully you can all see the screen and my presentation. And so when Louise asked me to talk to you, she wanted the focus obviously to be upon people, and people matter. People for me is a huge subject, one I'm very passionate about. So I'm going to talk to you about the key issues that you need to consider if you decide you want to bring people into your business because you're expanding, whether that's now or in the future. Hopefully what you'll learn this morning will be, I've been plunged into darkness for some reason. But hopefully what you learn this morning will be useful and will give you some pointers which you can then build on if you then decide you are going to bring people into your business. There will be opportunity for questions at the end. And I'm very happy to answer any questions that you have. So, what are we going to cover? We're going to cover 6 different areas. The first is the status. Is your person going to be an employee? Are they going to be a worker? Are they going to be genuinely self-employed? These are really important questions because they influence the sort of contract documentation you'll need to put in place. They'll influence the person's rights. They'll influence your obligations to them, what it's going to cost your business to engage them. And it'll also influence how you deal with them going forwards, and particularly, for example, if you want to end the relationship. So key important first point, really, if you're going to recruit somebody, is to look at whether they're an employee, worker, or genuinely self-employed. So we'll delve down into that. The next point is to look at the written statement of particulars, which I'll explain more about when we get there, and contracts of employment. Assuming you're engaging an employee, what does the document look like that you're going to have to give them when you bring them on board? HR policies and procedures, another area that you need to think about. There are some policies that you definitely need to have in place. There are other policies and procedures which may be desirable in time. You don't necessarily want to have everything in a handbook, for example, that's huge. Right from the beginning, it just becomes daunting and unnecessary. So we work with quite a lot of clients just looking at what they need, and as the business grows and evolves, then we can build on that. Probationary periods. I get asked about probationary periods quite often, so I thought it was a good slot to have a look at probationary period. Do you need it? How it can be useful? how do you deal with it? How do you deal with a situation if somebody doesn't succeed during the probationary period? Then we look at ending the relationship. That's obviously a big topic in itself, but we'll just do some pointers in terms of things to think about there. And then keeping the good ones, as I've called it, really important. Once you've got somebody who's really successful in your business and you enjoy working with, then how do you hang on to them? Why do people leave? What can you do to avoid that? So if we move on to status, just a bit more about why does it matter? It matters because, for example, employees have the most rights. They have the right, for example, not to be unfairly dismissed. They have the right to holidays, as do workers. Both workers and employees have the right to national minimum wage, to pension. There are specific rules around how much notice you must give an employee, which doesn't apply to a worker. There's a right to redundancy payments after 2 years for employees, but not for workers. So it really does depend who you're engaging, or whether they're an employee worker or genuinely self-employed, in terms of their rights. Tax treatment, obviously, if they are an employee or worker, then you're going to have to set up payroll and pay them through the payroll, deducting tax and NI as appropriate. If somebody's genuinely self-employed, that isn't going to be necessary. They're going to send you invoices, perhaps on a monthly basis, whatever you agree, and you're going to just simply settle those invoices according to the terms you've agreed with them. Contracts, policies and procedures, as I said just a few moments ago, depending on whether somebody's an employee, worker or self-employed, will influence what sort of document you give them when you engage with them. So if it's somebody who's genuinely self-employed, then you'll want to give them some form of consultancy agreement. If it's an employee, then you'll want to give them a contract of employment. And if it's a worker, there'll be a similar sort of contract, and there are minimum pieces of information that you need to include within the documents that you give to them by law. So if we look at employees to begin with, there are 4 factors which are typically taken into account by an employment tribunal when they look at whether somebody is an employee. Let's say, for example, you've engaged somebody as self-employed, but actually over time they work in a way that really ticks all the boxes of being an employee. And that's when you might end up in an employment tribunal. And look, I'm not suggesting this is going to happen frequently, but sometimes there's an issue over status. And then the tribunal would be looking at mainly 4 different factors. I do want to say, though, having sort of honed down these 4 factors, which I'll go into a little bit more detail about, that actually what the tribunal would have to do, the employment tribunal would have to do, will be doing, is to paint a picture of the scenario in practice. So whatever you say in your documents, what they will want to know is what actually happens in practice. And they paint a picture, taking into account all the sort of factors of how the relationship works in practice, and then stand back and take an overall view of all of those factors to determine whether somebody is actually an employee or worker or self-employed. So if we look at the first point, generally offer own work in return for pay. This is what we call personal service. So basically, it's not just about getting the job done. It's important that you have that particular person with their particular skill set that you've gone out to find, who is carrying out the work for you. So the work has to be done personally by that particular individual. The second point must be subject to sufficient degree of control by the other party. So this is about control. And control is basically about the employer deciding how the work is done, what work is done, when it's done, where it's done from. So controlling basically how the job gets done. And if it's an employee, then generally speaking, the employer will be in control of all of those factors. If it's somebody more senior, there'll be perhaps a little less degree of control, and it does depend on the type of work they're doing as well, of course. The third factor is mutuality of obligation, a legal term. Basically, it means that there's an obligation on the employee to do the work that's offered by the employer. There's an obligation on the employer to pay the employee for that work, and to pay them also perhaps when there isn't work. And there may also be an obligation on the employer to give them work. So there's an expectation all round that there's that kind of engaged relationship between the two, where they won't be letting each other down. The final factor is other provisions of contract consistent with contract of employment. So that's a sort of catch-all legal phrase. What it boils down to in practice is looking at all of the other factors like how the person's paid, what equipment do they use to do the job, who does it belong to particularly, do they use the employer's equipment or their own, are there any benefits provided to the person carrying out the work, so it's more consistent with them being an employee. Benefits, I mean, not just pension, but maybe medical insurance, whatever it might be appropriate within your sector. Are they free to work for other people? And again, there's no set list here really, it's a case of sort of painting an overall picture. If we turn now to look at workers, the main distinction between a worker and employee is usually this absence of what I refer to as mutuality of obligation. With a worker, there's usually not such an obligation to provide work or necessarily for them to do the work when you go to them and say, we've got this work available. The definition is set out on the slide. It's an individual who enters into or works under a contract of employment. So workers include employees as well, but they also include another group of people who work under any other contract which requires them personally to do the work, whereby they're not, however, working for somebody as if they were a customer or client of their business. So in other words, they're not sort of self-employed. Now look, these issues, I've kind of whizzed by in a few moments, but they sometimes come up and end up in litigation for years. And a very classic example of that is the Uber taxis situation, which I'm sure everybody will have heard of. Litigation started something like 6 years ago when Uber tried to argue they were a customer of the taxi drivers. The tribunal found in the first instance that that wasn't the case, and that the taxi drivers were actually providing a service to Uber, which they did under Uber's control with performance management ratings, depending on the number of lifts that they gave. They were subject to disciplinary process if they didn't carry out the job in the way that they should, and Uber determined the fares as well. So fundamentally, they were working for Uber, making profits for Uber. And since then, Uber have challenged all the way through the courts to the Supreme Court, and only recently failing each time to overturn the decision that rather than being self-employed, these Uber taxi drivers were actually workers. The significance of that is that they were entitled to the national minimum wage, and also entitled to paid holiday as well. So it's been a big piece of litigation, and it just demonstrates actually that even people in big businesses can come unstuck in terms of how they actually decide to engage or employ somebody, and it does need a little bit of thinking at the outset. And more importantly, as in the Uber case, looking at what actually happens in practice. What does this really mean? Well, I think to take away is that when you decide you want to bring someone on, unless they're going to be genuinely self-employed, then take a little bit of advice about whether you're going to be engaging them as an employee or you're going to be engaging them as a worker. It doesn't have to be necessarily costly, but it's probably time well spent up front. Now, I'm going to start to focus now more so on workers and employees and leave the self-employed to one side for the moment. Looking at if you're engaging somebody who's a worker or an employee, what sort of paperwork do you have to get prepared? Well, there's something called the Written Statement of Particulars. It's requirement under the Employment Rights Act. It's basically certain information that has to be given to the individual in writing. And on the 6th of April last year, the law changed slightly in this respect, in the sense that now that information has to be given before the person starts work or by day one, and it has to be given to both workers and employees. Now, what is that information? That information is, in a sense, a lot of it is quite straightforward. It's things like who's the employer, who's the employee, how much they're going to work for, how frequently they're going to get paid, what are the pension arrangements, what are the holiday arrangements, what are the sick pay arrangements. But a couple of other things were added in April last year, things like training. Is there any compulsory training required for the role, and who pays for that? And what about other paid leave separate from sick pay and holiday pay? So there's a sort of set list of information set out in the legislation that you have to cover off when you set out in writing the terms of somebody's employment or workers' agreement. And I guess I'm always a fan of people putting together the contract right at the beginning and almost sending that when they make the offer to the individual, because then the person knows exactly on what basis they're being engaged. And that becomes even more relevant, I suppose, the more senior somebody is, the other clauses that you might also, taking into account the other clauses you might also want to include in the document. Because we then move on to the contract for employment. Well, why is this different? It's basically just the contract includes all the written statement of particulars usually, but then some additional clauses too, which is designed to protect your business or to assist the employee in understanding better about how they should be operating within the relationship. Take, for example, a clause about confidential information and making sure they're keeping the information that they learn within your business is confidential. Making sure that any intellectual property is protected. You might have certain clauses that we call restricted covenants that protect your business when the employee leaves. So, for example, stopping them from taking some of your staff, setting up elsewhere, working for a competitor, interfering with supplies, taking customers, clients, that sort of thing. Then they're problematic, all those clauses, but that's not to say that they're not worth considering to put into a contract, particularly where you've got somebody who's customer facing. And that's obviously important for your business. I've put here doesn't have to be in writing. Now you do have to set out in writing the written statement of particulars. What I meant by that statement was really that remember that when you make an offer to somebody and they accept it, then you have a binding contract. So if you're not sending the whole contract at the beginning and you're just sending an offer letter saying, we'd like to offer you the job on the following sort of main terms and the contract will follow, do make sure you get that accurate because once you've made that offer, if they've accepted it, then you have a binding contract. And when you make an offer, also think about whether there are going to be some conditions. So for example, is it going to be subject to references? Is it going to be subject to checking the right to work? Obviously it should be. Is it going to be subject to them being able to start on a particular date? Only yesterday I had a question with a client who had made an offer to somebody to sign a contract actually to start in the middle of May, and now they can't for family reasons and they're abroad and can't come over. So a few things to think about. What are the conditions around the offer as well? HR policies and procedures. So what must you have? So right at the beginning, when you engage somebody as an employee, then you need to have in place disciplinary rules and procedures. It's a few pages long. It includes a list of the examples of gross misconduct, so everybody's clear about what behaviour is acceptable and isn't acceptable and what might result in their immediate dismissal. It might also have examples of less serious misconduct that might subject them to warnings rather than dismissal. But it'll also have the process that you need to follow to terminate their employment fairly. And that is particularly important if the employee's been with you for at least 2 years, because after 2 years, the right to unfair dismissal, claim unfair dismissal kicks in the general right. That's not to say there aren't some exceptions to that. And if somebody, for example, was subject to discrimination, they could bring a claim from day one. You probably know you can also find claims of discrimination within the recruitment process if it's not fair and if somebody is prejudiced for what we call protected characteristics such as their age, sex, race, pregnancy. So disciplinary rules and procedure. The other procedure that you must have in place is a grievance procedure. So basically, a fairly short process. What do people need to do if they have a complaint that they want to make official? Always, it's better to try and resolve matters informally in the first instance. But if an issue has to be formalised, then usually it's using the grievance procedure. So that's another process to have in place. Beyond that, it is advisable to think about health and safety policy, data protection, an equal opportunities policy, anti-harassment and bullying policy. And then separately, there may be a number of other policies. There are, for example, what I call family-friendly policies, policies about what happens when somebody wants to take maternity leave. Now, you could have a maternity leave policy in place, even if you just follow the statutory regime of giving them the sort of minimum statutory maternity pay and time off. But at least that policy will help them understand when they have to let you know what their entitlements are when they're on maternity leave. Their right, for example, to what we call keep in touch days if they want to come back for up to 10 days during the maternity leave to do work or training with you. There are a lot of other family-friendly policies, and when a business is quite small, I always say, look, let's not include all of those in a handbook. It becomes crazy, incredibly long document to work around. But you can include links that are helpful for your employees, links through to the government websites, which have sort of summary information, and also ACAS is a very good source of information about people's rights to paternity, parental leave, bereavement leave, shared parental leave, all of these other rights that employees will have. You may want, for example, to include a policy about your compassionate leave, what you pay in the event of a death in the family or close family. Expenses policy, if somebody is incurring business expenses, how they go about claiming that and what they can claim for. You might want to have a separate policy that deals with poor performance and sickness absence. And you might need to have a policy about anti-bribery and corruption. I mean, there are a number of other policies, retirement policy, redundancy policies. These are not really ones that you need as a small business. So it's really a case of looking at the type of business you've got, how many employees you've got, what are the employees? Are they likely to be having children and therefore maternity policy is key, or is that not actually relevant for you at the moment? There's no point in having things that aren't necessary. And you don't have to have those, by the way. It's for information. And say, have the disciplinary, have the grievance procedure, the rest is for information. Although I want to correct myself slightly there, data protection really important, particularly since GDPR came really into focus. So having a data protection policy is important. How do you ensure your employees know about your policies and procedures? So many clients that I know have small businesses, understandably, are really busy doing the job that they need to do to get that business to thrive. And they don't think necessarily about having a policy or procedure that is current and available to the employees. So make sure that if you've got this, you've taken the time to put it in place, that it's somewhere where employees can access. I'm not a big fan of printing copies off and circulating around the office. When you come to update them, it's difficult. You've got different versions around. It's not environmentally friendly either. So you could have an intranet site where employees can access policies and procedures. They can be in a form of a handbook, staff or employee handbook, or they can just be there available for them to click onto with links through to websites like, as I said, the government website for information or the ACAS website for information. And don't forget to, I think, just set aside 10 minutes maybe once a year to think, do we need to update these? And if you're engaging an HR consultant or you've got somebody in-house or you engage employment lawyers, then touch base with them and say, look, has anything really happened in the last year that means we need to update our policies and procedures? We, as a rule, sort of diarise to update after 2 years with a client if we've drafted a policy or procedure or contract for them. And then if something changes in the law in the meantime, then we would contact our clients to let them know. So, moving on now to probationary periods. I get asked about probationary periods quite a lot, as I said at the outset. So I just thought it would be useful to talk about them. And what I've actually done is included on the slide an example of a probationary period clause. So this basically starts off by saying the first 3 or 6 months of the employment of the company which reaches a probationary period. First of all, you don't even have to have a probationary period if you don't want to. It's not a legal requirement. But if you do, it's one of the things that you need to include in the statement of particulars. So you need to say whether there is one or not, and how long it's going to apply for. 3 months is 3 or 6 months is fairly typical. And as you see at the end of this clause, the opportunity to extend it at your discretion if you need to is the other typical part of the probationary period. The other reason to perhaps include it, or a couple of other reasons to perhaps include a probationary period, is that it helps to manage expectations. It helps, I think, to focus a manager in terms of the importance of keeping a check on how the employee is doing in those first 3 to 6 months. And really key that if there are things that need to be raised, areas that perhaps the employee needs to focus on, that you do that during the probationary period. It's never ideal for somebody to find out at the end of the probationary period that actually things weren't working out and they're not going to be kept on. The other reason that it can be useful to have a probationary period is because it gives you the opportunity to carve out a shorter period of notice, separate from the notice that might apply once the probationary period has come to an end and the relationship has been confirmed as successful. And I've put in there 1 week. It doesn't have to be 1 week, it could be 2 weeks, it could be a month. But it's an opportunity, as I said, to have a slightly shorter period that you can use to terminate somebody's employment during the probationary period or at the end. And then after that, you might think about having longer notice periods that apply as the relationship carries on. And on the subject of notice periods, there are minimum notice periods that apply to employees. From the company, from the employer to the employee, the notice is 1 week for every full year of employment, rising up to a maximum of 12 weeks. So 10 years employment, 10 weeks. And from the employee to the employer, it's only ever a week. So think about that in the sense that you might want to agree something different. So it's important that you do think about the notice periods when you're drafting a contract. Those are minimums, you can exceed them, but you can't offer less notice. Ending the relationship. This is obviously a huge topic, could be a whole presentation in itself and more, because under the Employment Rights Act, there are 5 fair reasons for terminating somebody's employment, and that is particularly relevant if somebody's been employed for at least 2 years, as I said before, because then they have the opportunity to bring a claim of unfair dismissal in the employment tribunal. So one of the things the first thing that I wanted to look at when you think about ending relationship is to think about who you've got there. Is it an employee? Greater rights? Is it a worker, or is it somebody who's self-employed? If it's somebody who's self-employed, then you basically honour the terms of the contract you have with them, whatever you've agreed the notice provision should be. If it's the employee, minimum notice periods applies, I've just explained, but you might have had something different in your contract. And with the worker, you may have, hopefully you've had an agreement, a statement of particulars, which has set out the notice periods that are going to apply. The other point to think about is what's gone wrong. And the reason I ask this question is because if I'm contacted by a client, even if it's during the probationary period, to say that we want to get rid of, it sounds really callous, doesn't it? Or we want to terminate this person's employment because it's not working out. Then I always say to them, right, let's do just a mini risk assessment, which basically is you tell me what the issues are, and then we can sit and risk assess together. Are there any issues that are particularly concerning? For example, is there some sort of discrimination issue? Has the person just announced that they're pregnant? Is that relevant to your decision? Even if it isn't, it's a factor that you might need to take into account because their perception may be that that's the reason you're terminating, and that's obviously discrimination. So just what's gone wrong, is it poor performance, is it misconduct? And that's also relevant because if they've been employed for you for 2 years, then obviously you need to make sure that that dismissal is fair. And depending upon the problem, depending on the reason for you wanting to terminate employment, that will determine the process that you need to follow to ensure that the dismissal is fair. What is it going to cost you? If it's a redundancy situation and the employee's been employed for at least 2 years, they will be entitled to a statutory redundancy payment. In any event, they're going to be entitled to their notice pay. Is that just salary only, or is that also the value of their benefits? What about accrued but untaken holiday? What does the bonus or commission structure look like? Are they entitled to some money from that when they leave? So these are things to think about in terms of what it's going to cost you. And one employee who's not been with you very long is straightforward, but as you grow in size and perhaps you restructure and you need to make a number of redundancies, then you will want to cost that out, because you'll need to know what your budget's going to be to undertake that exercise and ultimately what you're going to have to pay everybody. And when you think about it from a cash flow point of view. Do you need professional advice? I think it's worth taking advice if you're going to terminate somebody's employment, certainly if it's an employee with 2 years service. However, even if it is somebody with less than 2 years service, it's perhaps good use of time. I'm conscious of the fact that I would say this, wouldn't I? But it really only needs to take 10 minutes, perhaps, to run by somebody, an HR consultant or an employment lawyer, the scenario, and just check there's nothing that you've missed that means that you might be vulnerable to a claim, or that you might need to be paying more money now than perhaps if you wait, for example. So I think taking advice is a good idea, and it doesn't have to be expensive, and it doesn't have to delay your decisions. The other thing to say is that if somebody has been employed for at least 2 years, taking advice can be useful, because there are other ways of ending a relationship than simply going through the formal process you should follow depending upon the reason. There is the opportunity to have what we call a protected conversation with the person, where you sit down and have a straightforward conversation with them about the issues and offer them the option of leaving under what we call a settlement agreement, which is a contract which compromises their employment rights in return for a slightly enhanced payment. But what it does mean is that they go off and take independent legal advice, and ultimately the employment relationship is brought to an end under the settlement agreement, and it's closure for everybody. Now, I know some clients are nervous about sending their employee off to take independent legal advice, but if you're properly advised about realistically what that person's rights are, what they should be entitled to, and the conversation is set up correctly too, then it can be a very useful and pragmatic and easy and sort of straightforward way of bringing the employment to an end without the risk of litigation. Keeping the good ones. Why is this so important? High staff turnover probably impacts on your business performance. If you've got people coming in and leaving, it's very difficult to get somebody established in the role, doing the job well, engaging with your customers if you're customer facing, and building a rapport and ongoing relationships with customers. Recruitment can be costly. It's certainly time consuming. Obviously, it depends on the sector you're in and the type of role you're looking for, but some roles can be quite difficult to fill, where you're looking for rare skill sets. Once you've got somebody, it's important to hang on to them. If you've used a recruitment agency, obviously you've paid probably a significant fee. I talked about customer relationships. They can be damaged, the business disrupted. If that person is customer facing, if you lose somebody and it takes time to replace them, then you've got downtime where you're not selling, you're not building a rapport with a view to selling, and that costs business money. Inducting new staff, that takes time too, not just the induction process itself, but also bringing somebody up to speed. Even if they are experienced in their role, they're getting to know your company, they're getting to know your colleagues, they're getting to understand how you do what you do and how you would like them to do what you want them to do. So it is important to keep those good people when you find them. Why do people leave? Interestingly, it's not very often that somebody leaves because they're unhappy with their pay. and they're looking for more salary. That is fairly unusual. It might be a factor. For example, if they feel that their treatment is unfair in terms of the allocation of pay rise or bonus. But generally speaking, the reason why people leave is because they're dissatisfied with their job. Perhaps they're frustrated in their role, maybe their ideas aren't being heard, maybe they want to be promoted and there's nowhere for them to go. But generally speaking, it's job satisfaction, dissatisfaction, the prospect of taking time out of work. That's obviously nothing you can do, something you can't do anything about really. If they want to go off and retrain in a different role, perhaps they need time out to recover from the sickness. Perhaps they're taking time out for family reasons, sabbatical. But that's also something that maybe you talk to them about. Perhaps you agree that they have a bit of time out, but they come back. And then you don't lose them in the marketplace when they decide they want to return to work. Poor relationships at work. This is one of the key reasons. Now, this is not something that I've made up. When I came to prepare this, it's long been the case that I've known that people don't leave for salary. But interestingly, there was a CIPD. CIPD is a professional body for personnel management professionals. CIPD fact sheet that was completed only in April of this year, which identified issues around why people leave. And one of the key reasons was poor relationships at work, in particular poor relationship with line managers. And then only last week I liked and shared on LinkedIn a post that ACAS had put out, which was about the importance of inclusive management style, open management style and communication in the workplace, and the importance of encouraging different ideas really helps a dynamic business to grow. So line management relationships really key, communication really key, and even more so I think in this time when mental health, which is a particular passion sort of subject of mine, but mental health has really come to the fore in the COVID times that we've had. People have been working from home and there's been lots of stresses and strains on people. But it is an ever-increasing concern, and employers need to be thinking about it even more so these days. So how to encourage a more positive workplace? The first thing to do, or to perhaps to think about, is if somebody leaves, hold an exit interview. Doesn't have to be very long, it might be 5-10 minutes, just have a quick chat with them over a coffee perhaps, and see why they've chosen to leave. Maybe you already know, but sometimes these exit interviews can throw up patterns or really useful feedback that perhaps somebody hasn't said during their employment, but they feel much more comfortable about sort of throwing into the mix as they leave. And sometimes it's things that you might want to then act on, make changes in respect of going forward. Flexible working is, again, something that's really become much more prominent since we've had the pandemic. Many more people have obviously been working from home because they've had to be, and now many more people are continuing to work from home, even if it's on a part-time basis, as we are nevertheless able to return into the office. But it's not just about that, it's also about flexible hours, perhaps people returning from maternity leave wanting to work more flexibly. Sometimes it can be about people wanting to fit it around a hobby or another job that they have. Obviously, it depends on the type of work they're doing for you. So being flexible where you can, and it suits your business to be so, is something to consider. Treating people fairly, it sounds like stating the obvious, but going back to the point I was just making, unfairness, and particularly unfair treatment from line managers, can be really damaging in the relationship and a reason why people leave ultimately. The perception of fair treatment is really important, and particularly around issues such as pay rises, bonus allocation. So really important to be consistent and apply any criteria that you have consistently and talk to people. If you can't allocate the bonus or you're not allocating a bonus this year, explain why. If you're delayed in making your decision, let people know. These are the sorts of issues that when I have employees come to me, they are particularly unhappy about and get particularly frustrated about, and then it just kind of builds, that resentment builds. Employee well-being, as I've said, really important to think about employee well-being. How are people coping, particularly if they're working from the office, working from home? Have a means of communicating with them and having team meetings and involving staff. Perhaps think about having some sort of well-being program that they can access if they need to take advice privately about an issue that's causing them stress personally, professionally. Enable career development and progression. That's obviously more difficult in a much smaller business, but as your business develops, you will be thinking about how you can use people in different ways. And I'm very familiar with the fact that you might bring somebody on to do one role, and then 6 months later they're developing into doing some slightly different role, which suits them better and suddenly becomes a need within your business. So being open to those changes and having somebody actually who's also prepared to be flexible, particularly when you're operating small business, is really valuable. Consult and communicate with employees, as I've said. This is really, really important to keep the dialogue flowing. Have an open door policy if you can. Allow people to come and talk to you when they need to discuss issues. It really does help to encourage people to be open and resolve issues early. And that was another point actually that the ACAS report that I referred to was talking about, which is the value of resolving issues really early and not letting them fester. By the way, I've referred to the CIPD fact sheet, I've referred to this ACAS posting. I'm really happy to send links to these to people if they want to email me afterwards. It's no problem at all. And that is it. I really hope you found it useful, and I hope I'm on time, and I'm very happy to answer any questions at all.
Brilliant. There you go. Well done. Thank you very much. That was, honestly, there's so much information in there, Joanna. But it was delivered in such a calm, precise way that, you know, often when we talk about sort of employment and everything, you get that sort of panic of, oh God, it's such a minefield. But I think when you break it down into those small chunks of the obligations, what we have to do, what they have to do in a simple format, and I think everybody would agree that, you know, if you do it right at the beginning, as you said, from the offer letter, get that in right at the beginning with the correct, you know, it's a good starting point. And often we fly off with these offer letters saying, yeah, we'll get them in, just send them a letter. But it's so good to take time and take stock and get it right from the beginning, because that will obviously then alleviate any future problems that we have. So thank you. It was a really, really insightful talk. Thank you very much. We're going to upgrade everybody now to panelists so we can see everybody, and invite them in. And there we go. They're coming one by one. There we go. Let's get everybody in. Good morning. Nice to see you, Dane. I'd love a coffee.
That's what I do as well. You just missed me yawn.
Yawn? That doesn't sound good.
Oh, not because of the presentation. We just got the time.
I agree completely. I've only had the one of the two that I definitely need in the mornings.
I've got a couple of questions, so I don't know if you want me to wait or just fire in, Louise.
I think let's just get everybody in the room first. I think let's just wait to make sure everybody's in, and then, yeah, you can fire away. Let's have a look. I think everybody's in. There we go. Right, Dane, over to you. Do you want to, before you put your question to Joanna, do you want to just very briefly say what you do, what your business is? Because I think that always gives a little bit of, good sort of insight to Joanna, so she knows your business.
Okay, so in February, we converted out a horse box into basically a mobile coffee shop. we've done really well. We've got a second trailer on its way in a week or two's time, and we're going to convert a shipping container in Alton by the summer. So we've gone from literally Tracy and I, who started the business, to I think I'll have 6 to 10 employees in the summer. I've already got 2, one full-time, one part-timer, which was sort of a year down the line, not after 12 weeks. We've always worked with people. Tracy and I have always been managers, sort of senior level operations managers. So I'm quite familiar with HR processes, because usually we were the one doing disciplinaries and such forth. I guess the 2 questions I've got on that basis is that whilst Tracy and I have always dealt with contracts and stuff like that, is there any protection for a small business in the fact of it's a small business? So tribunals take that into account, or does it still need to be belts, braces?
So first of all, you are the dame that has the coffee and cake outside base, aren't you?
That's it, yeah.
So you can recommend both the coffee and the cake. In fact, it's lethal. The cakes are amazing.
Thank you.
So there aren't really any exceptions, no. So for example, I talked about that statement of particulars of employment, which is basically sort of critical information that you basically include then in your contract of employment if you're employing somebody. There's no exceptions there. You need to put that in, regardless of whether you're a small or a large business. That information has to be given to the employee or the worker. I guess thinking about, the tribunal will take into account the resources of a business when they're looking at how you've decided to deal with something. So let's say, for example, this is an example that immediately comes to mind. You're dealing with a disciplinary matter. At the end of that process, if somebody's been employed for 2 years, it's really important you're getting it right, because they can claim unfair dismissal. You have the right of appeal as the individual. You might not have somebody else for them to go to who hasn't, who's more senior than you, who hasn't been involved in the process. So there's a situation where they may, take into account that you're a small business and the resources that you have in terms of how you've chosen to deal with it. But fundamentally, the principles of, there has to be a fair reason and a fair process followed apply to all businesses.
Okay. So then my second question is, as a brand, I quite like that we're sort of a little less corporate, sort of definitely as we grow. I'm even considering changing my logo slightly to make it, I think when I've seen it on stuff, it maybe looks a little bit too corporate. I saw a contract that Gourmet Burger Kitchen did, which was literally 1 page. It was 1 page, and it was colour splodges on the page of just vital information the employee needs. What's your thoughts of doing something like that? Or again, would you be best advised belt braces 12-page document, or would a 1-pager, as long as it's got the key information on, be sufficient?
Oh, right, completely cool with splodges, whatever you want it to look like. I've done handbooks for people where it's a kind of, we had a client who was an online dating website, and they wanted it to be much more approachable and friendly, down to much bigger companies who are much more corporate in the way that they deliver the way they speak, even in documents. Completely understand that, no problem. I struggle to believe that they can tick all the boxes in terms of the information that has to be given to that person in 1 page. And don't think that you would really get the best terms for you as an employer as well. I mean, just take, for example, a notice period clause. You could have the right to make a payment in lieu of notice. What that means is, instead of them work their notice, or you may know this if you've been in corporate world, but instead of them working their notice or being put on garden leave while they're employed but they don't have to come into work, you just pay them a lump sum. And you could make that just the salary payment only, so you're not having to pay out their pension, and you're not having to pay out you know, if there were any benefits. There may not be benefits, I appreciate it may just be the pension in the situation, in your situation at the moment. And, you know, so the detail, it doesn't have to be long and legalistic, but that detail needs to go somewhere. It needs to go in the contract. And it's very difficult if you're going to be comprehensive like that to put it on one page, unless the print is tiny. I'm fascinated. If you want to show it to me, I'll tell you whether I think it's even meeting the requirements. Did it link through to, was it an electronic document that linked through to other pages?
No, it was literally, it was a one-page document, and it literally had everything you need to know, and it had like a splodge for holiday, a splodge for working hours, and it was literally all on one page. It looked amazing. It was sort of, I think, for when, especially the type of employees I'll get, sort of probably under 25, it's sort of.
Well, look, you know, an idea is I did an induction.
Right, sort of easy to understand. Yeah. This is everything you need to know.
So I did an induction, we're not talking about contract now, but an induction program for a sailing club. And that was online. And we had clouds in a sailing boat, and each cloud was a different area, and you clicked through to other information behind it. So if you were going to have it available electronically, then I guess there's no reason why you couldn't you know, have a splodge with holidays, but then you click through and that just has a short holiday clause. And you know, you can be inventive, but the information's got to be, having said that, certain information's got to be in a single document. That's what the law says too. So I'm intrigued. Sorry, that's all I can say. I'm intrigued.
I'll see if I can find it and send it on.
Yeah, do.
Can I just say, I'm wondering if it was a freelance contract, Dane?
Well, yes, exactly. And then you don't have such a requirement to give certain information.
Being it was GBK, I doubt they have freelancers. They're sort of but bound to be employees, given that they run restaurants.
Yeah, true.
So that's not necessarily true with the 0 hours, Dane. There's a lot of flexibility around the 0 hours. I think you'd agree, Joanna, is that right? That opens up that people is a dependence on whether people work regularly.
Well, no.
So
the requirement to set out certain information under the statement of particulars requirement applies to workers, applies to employees. Now, 0 hours workers are typically workers because there's that lack of mutuality of obligation that I talked about. But they're nevertheless workers, and so they still need to have that information set out in writing to them. Yeah, so, you know, it can be a shorter document, but it still needs to be comprehensive. Yeah. I really am amazed if you can get it onto one page.
Well, there's a challenge for you, Dane. Find that document. Come on.
It was on LinkedIn. I'll see if I can find it now.
Brilliant. Thank you.
I'll give you my email address. If you email it to me, I'm happy to talk to you about it. If you want to try and recreate something like that, I'll tell you whether I think it's possible.
Yeah, I just think, especially in my field, it's I just think it sort of hits my target market of employees to make it digestible more than anything else, rather than giving them, for want of a better term, a lot of waffle that they might not understand. It's nice to have it so they can easily understand it. So as an employer, you don't answer 12 questions all the time, even though they've got the information. It's just in a simpler format for them to understand.
Yeah, no, I completely understand. And, you know, we work with all sorts of clients who do not just corporate. You know, some are landscapers, some are decorators, you know, some work in the office at Canary Wharf. You know, you've got to tailor things. I completely get that. So, yeah, interesting.
Brilliant. Thank you, Dan. Has anybody else got a question? Jo.
Hi. Morning, Joanna. Thank you. That was amazingly spot on for me, because I'm literally at the point where I want to take on a couple of art tutors. So Escape to Art is my business. I'm an artist as well, which I've picked up more and more because of COVID, because my classes weren't running. And now I want to basically outsource a bit of my classes because I want to paint a bit more. So I'm looking for art tutors, probably to work maybe maximum of 6 hours a week. I typically run a pay-as-you-go art class arrangement in the daytime, so people don't come to a whole term necessarily. They might just be very ad hoc. And I think the way I want to start is by getting freelancers in, a freelance art tutor who could pick, I'm going to design the course, or the sessions, should I say, but they can decide what times they want to run them and on what days. I'm trying quite hard to steer away from the employee situation at the moment, purely because I'm such a micro business. I don't feel capable. I don't really want to turn myself into an HR person. I don't feel like I've got time. Is there, I suppose what I'm asking is there any allowance for freelance to employee type situation within this scenario? To go full into a part-time employee seems, it's a heck of a jump. It's quite daunting.
I don't think you need to. I think if you're engaging them with some flexibility in terms of, you know, they choose when they're going to run the course, perhaps, and you know, maybe you do, you know, you maybe have a couple of people. So if one isn't available, then the other person can deal with it. Then I agree that's probably the better way to start, because it's quite yeah, much more flexible. Basically, you're not demanding that they're available at a certain particular time. You know, they can tell you what they can do, and you can work it from there. So I agree that sounds like a sensible way to go. And then if you expand and you've got more certainty also over the numbers of people wanting to do the course, and therefore, you know, you commit to it more, then you could, you know, you can think about taking somebody on potentially as an employee or worker.
Yeah, okay. There's a few of us in Signal who are thinking of taking on tutors. And I guess it's just I'm trying not to push the boundaries too much, but I am trying to flex the arrangements so that I don't find myself heading down the HR route too quickly. I feel like I sort of feel like I should be taking people on as employees, but because it's so daunting and time consuming, I'm sort of pushing the arrangements more to the freelance. So I feel a bit like I'm not really being quite fair to the system. Does that make sense? It's just a slightly uncomfortable position.
I don't think like that, because you know, it suits some people to have that flexibility and to be self-employed and to, you know, offer the services when they can, and you know, so it's not you're not taking advantage. People won't do it if they don't, for you. They won't work, you know, they won't engage with you if they don't want to work in that way. So I don't think so. Do you have this issue? Whole question of status.
Yeah.
It's not just about employment law, it's also about tax, isn't it?
Yeah.
And what HMRC like to think about it. So it's also an issue that, you know, you can talk to your accountant about as well.
Yeah.
Happy to talk to you about it, obviously. But if you talk to your accountant about it.
Yeah, I've had a few conversations. I've gone round and round a few times for a couple of months, to be honest, and I'm sort of at the point where I just need to decide. I think I'm there. I think I know what my contract wants to look like. I get a little bit scared that if I have a freelancer, obviously I can't expect an awful lot back in terms of notice periods and commitment and non-competition and non-solicitation and all that. But I think I've settled on the freelance model for now. Like you say, a couple of people, so I can keep it all very flexible. Yeah, but I do go round and round the houses. I mean, the thought of payrolling as well, it just sort of freaks me out a bit.
Yeah, well, look, don't be too freaked out, because there are lots of accountants who offer payroll. It's not necessarily because there are still these things are done with software packages. Yeah, I mean, and don't forget also, whatever you start off doing, I mean, if you have a contract, a consultancy agreement, you know, a freelance agreement with somebody, you'll be able to end it if it doesn't work out.
Yeah, exactly.
And you know, particularly, you know, unless they're going to argue that they were really an employee and they, you know, 3 years down the line, it's unfair dismissal. You know, there's flexibility, and you can build that in, can't you?
Yeah, absolutely. I mean, it could be a win-win. Sorry, say again.
I'm happy to talk to you offline more if you
Thank you, Joanna. Yeah, that might be very good. There might be a few of us who join, thinking of Vicky and Sarah. Yeah, that might be really good. Thank you.
Brilliant. Sarah Beth, hello.
I'd say something on that point, Joe, and to Joanna, Joe and Joanna, I love it. That it's quite normal for an organisation to have a set time period of contract, 6 months or a year.
Okay.
And perhaps something that's maybe you can look at within this, that you have a contract that's for the time, as you said, if it's a certain period of time, and then it's reviewed. There's also something I've had to sign as an employee and as a supplying a service, and that's a non-disclosure agreement of any data or any information that I think offers some form of protection for organisations when they have people coming into their organisation who obviously are part of it. And I don't know what Joanna thinks on that side. And there are quite a few organisations, I'm thinking bizarrely enough, of things like swimming instructors at our LIDA, you know, people that are taken on for a season or for a certain period, and it's obviously weather dependent at the LIDA, that sort of thing. So perhaps there's some previous agreements that are quite solid, say with, for instance, you know, sports centres, things like that, that are term time, educationally, that might be of use to you. If there's any contacts that have those sorts of agreements with their staff. That's what my thoughts were, that it is possible. There's possibly
been done before.
I know it has been done before. Yeah,
exactly.
I think what I would say is, starting with the point about this, whether they're self-employed or employed, look at the tests that I ran through. They're not dissimilar to the tests that HMRC would also run through, but then ultimately, yes, and you could just have, if your courses are just going to run for, say 6 months, just have an agreement for 6 months and then have a look at it after that. And NDAs, so an NDA might be used particularly in early discussions in a situation where you've got to disclose to somebody some really confidential information in order to have that discussion with them about maybe whether they want to join. Probably not so necessary for you, Joe, but they can be used. I've got a client at the moment just sort of setting up in business who you're going to use experts to advise other businesses, to advise people who want to get into other businesses. And so sometimes the early discussions will have to be covered by NDAs, but ultimately then they'll be taken on as consultants to advise as and when. It's very flexible.
I guess my drive for some sort of NDA is that I think my concept in terms of the pay-as-you-go classes, and I won't bore you with the details, but they're all materials provided, etc., etc. It's quite a nickable concept by another art tutor, and I don't have any protections in place to stop anyone doing that, coming and getting all the expertise off me training them up on how to run my classes, and then them disappearing and doing it for themselves. Now, obviously, there's loads of lovely things I can put in place to make sure that they benefit from me doing all the behind-the-scenes stuff, the marketing, and being part of a lovely little art family, and me selling their work, etc., etc. But that's my big vulnerability, I think.
Can I just jump in there with that? Because you talked about the protective covenants as well, Joanna. How enforceable is that? I mean, because you can have all these things in contracts that, people can't take your clients, they can't. How easy is it to enforce those clauses that you put in these contracts?
So those clauses are, the law is basically that they have to, that they're not valid and they're not enforceable unless they protect a legitimate business interest. Unless there's something in particular that needs protecting. And then there's a real reluctance by the courts to stop somebody from going and working in another business for a competitor, for example, because that's our right to be able to work where we want to work. If that information that they're trying to protect can be protected in another way. So clauses about stopping somebody from working for a competitor are quite difficult to enforce. Clauses that say don't take our clients, more reasonable. for a reasonable period of time after the relationship has ended, though. Clauses that say, you know, this information is confidential and should remain confidential, and these are examples of what it, you know, what is confidential, are, you know, much more easily enforceable. The reality is, and being completely honest, the reality is that that sort of court action rarely happens outside of big insurance sector business. You know, you might write a letter to your ex-employee saying, we believe that you've done this and we want you to sign these undertakings to say you don't, and if you, you know, and if you won't do any more, you haven't, or whatever, otherwise we will take action. But it's costly, it's complicated litigation, it's expensive. Do you want to involve your customers, your clients? You know, so that, you know, I'm going to be honest, the reality is it's really rare outside of London. I've practiced for over 25 years. I've only ever been involved in writing to people, sort of warning them off and reminding them that they're in breach if they do certain things. It's only when I worked in London that actually, you know, litigation has actually taken place. But that's not to say you shouldn't have them in the contract. And it is important, even if it's a consultancy agreement, to protect, you know, to protect your confidential information.
Yeah. Yeah, I guess at the end of the day, whether it's a freelance contract, self-employed, or it's an employer contract, if there's question marks over the enforceability of any of those clauses anyway, then it basically boils down to your relationship with that person, and yeah, trusting them and not opening them up to all that critical information too early and stuff. I mean, they won't be able to see everything. They won't see all my cost modelling and everything that goes on. But yeah, I am conscious that whoever, in whatever shape or form, comes on board with me, it's a vulnerability. So maybe it's just an issue whether it's a contract or a freelance. It doesn't, you know, it doesn't matter too much.
There'll always be competition in all our.
Yeah, of course. It's just one of those many risks, isn't it, that you just have to weigh up and decide whether to do or not, I guess.
Yeah.
Yeah, thank you.
I did have a question, actually. I know I keep dipping in. Joanna, I wondered what your take on the current IR35 status that's happening. Been involved in it myself a fair bit recently. Just from your perspective, you sort of touched on all the different areas around contracts and workers, but this is quite a massive change, especially for SMEs at the moment, with the IR35 consultation and assessments.
Yes, I did think about whether to mention IR35. It's a big subject in itself. And what's happened is that since it was delayed from last year, but for people who don't know, basically it's now in force from April this year. But of course, Sarah, there are exemptions for small companies. So I'm thinking that people who are running small businesses will probably fall within the exemption and not have to think about the IR35. Basically, IR35 becomes relevant if you're engaging somebody through a limited entity. So somebody comes to work for you and they have their own service company. The service company would normally deduct, you know, any tax or national insurance liability. Well, actually, realistically, people often will be employed by their own service company so that they take their income as dividends, and you pay on invoice. And what the HMRC have tried to do is to, well, they have done, is to put the onus on the client engaging the service company to look at whether, in fact, the relationship with that individual that they're using is akin to an employment relationship, in which case they should be paid through the company's payroll, rather than avoiding that and being paid by the service company in terms of dividends. Sarah, you might well be able to explain it differently to me. I'm trying to oversimplify probably. But I mean, I think there are, first of all, it's relevant if you've got people operating through service companies rather than coming to you in their self-employed individual capacity. And the first thing to look at is whether you are, in the scenario you're in, exempt because you're a small company. And that's to do with how many people you employ and your turnover and balance sheet. So that's something that, you know, you can check fairly straightforwardly, particularly with your accountant. well, I'm working on it too with some large clients. I've had to go through the assessment using the HMRC tool, assessed tool, to assess whether somebody actually, for all intents and purposes, is effectively an employee, and they're kind of hiding behind their service company. And in a few cases, it's proven that they have, and then they've chosen to take them on directly instead, subject to tax and NI, which the individual hasn't always liked the idea of. But
inside and outside of scope is quite a you know, it's quite a wary area to be involved in, because it's once you're in scope, that's completely. I know that if you're a sole trader, then that does to a certain extent exempt you, which is for the smaller side. But I know I am aware of SMEs engaging with larger companies who will fall within that threshold, and they're supplying on a regular basis over a long period of time within certain timescales, and so the relationships are shifting quite a bit in terms of the whole IR35 situation. So it is, you know, people, I think people need to be aware of it when they're looking at who supplies, if they're having a supply of a service versus whether someone's actually under their control in terms of hours where they work and it's over a long period of time. My feelings are within construction a lot of the time, and possibly IT, you know, accountancy side services, because it's such a long period of time that someone's not employed but offers that service at a set time in a set place. So yeah, I think it's quite an important area.
You're right, IT is exactly the area that I've been working in it, where you've got consultants who are consulting IT people who actually have engaged for years, and they don't work for anyone else even, but they operate through their service companies. It's a big, and a lot of companies who engage people like that, particularly in the city, have just said that we're just going to take people on as employees. We're not going to take the risk anymore. Yeah, there's on our website we have a blog, and there's an article about IR35 which sets out the exemptions for small businesses and just summarises it really, and things you need to think about. So 6 steps you can take. But I think for us, you know, the chances are for these small businesses it's not relevant.
But there are some quite larger businesses that are heading that way in the group, aren't there?
Yeah, definitely. Good, thank you for that. Has anybody else got anything else they'd like to ask specifically to Joanna, or just have a general discussion? Yes, John, morning.
Morning. It's more of a sort of paperwork, legal sort of question rather than a tangible one. But Fiona and I run a limited company. We do engineering, and it only has 2 employees. For 2 of us, we are the owners, we are the directors, and we are legally it's 2 employees. Apart from paying ourselves and keeping a record suitable for HMRC, are there any paperwork obligations as we are employees? Should we have a contract of employment for each other, for example?
Just as you say that, I sit here thinking I'm in exactly the same position as you. Do I have a contract for employment? No. Yeah, I mean, your own, well, your employer is of course your company, isn't it? And I suppose technically you should have a contract in place. But it is fairly unusual, I think, in practice in that situation. Yeah, unusual, because you will have some rules around how you operate in your memorandum and articles of association as a company, won't you?
Yes.
Shareholders agreement, perhaps, if you've got that in place. Yeah.
Business owners would be breaking all sorts of hours of work and minimum wage rules if they actually they actually have their own contract of employment. It would be not taking holidays.
Exactly. Can I ask a question? You talked about the exit interview, and I agree wholeheartedly with you about how important an exit interview is. I think, you know, I've conducted many of them myself, and indeed have had many myself. And I think it just you gain such knowledge. But are there any sort of rules that you have to adhere to with regard to the questions in an exit interview, or are they no longer an employee, so you can ask them what they like and they can say what they like? Is there any legislation around that?
Okay, so I wouldn't just, throw great abandon to the situation. They might still be an employee if you're probably having an exit interview before they actually physically cease to be, before they cease to be an employee. Yeah. And I think you've always got to avoid potentially discriminatory questions. So I do think we need to, apply logic.
But sometimes what you get back from an employee, especially if they are potentially disgruntled, they can be quite frosty sometimes. And they're very overly honest. So I was just wondering whether you're not allowed, but whether there is any framework that you have to sit within that interview.
Well, I think always you've got to be mindful of potential for discrimination, haven't you? And discrimination. Yeah. So I don't know, let's try and think of a live example. If somebody says, I really dislike working for you, to be honest. I've not been well for most of my employment. I had cancer last year and I'm still recovering from it. And I've really struggled to do my job well, and I just feel that you've been completely unsympathetic. The wrong answer is clearly to turn around and say, yes, you've been rubbish at your job throughout. It doesn't matter whether you've had cancer or not. We're fed up with you. I think these sort of questions, issue. I mean, it depends, of course, as well why they're leaving.
Yeah.
Because we haven't spoken about that. I mean, have they resigned or have you dismissed them? Generally speaking, we're talking about people resigning, aren't we?
Yeah, generally about people resigning. I just think that when you go through the interview process, you generally are asking the same question within the interview process. I didn't know whether that was to be repeated in an exit interview situation.
I hadn't thought about that. I hadn't thought that you would ask the same sort of questions you'd ask someone joining. And I think it has, my view is it just is a fairly kind of, obviously on your guard always, but inverted commas, but yeah, a fairly sort of relaxed conversation. Is there any feedback you'd like? I mean, not everybody's going to be cooperative, are they? Somebody who's really, not everybody who resigns goes away feeling really hacked off and never wants to talk to you again. But so you can get some constructive feedback.
Yeah, no, I think they're really valuable.
But you may be somebody who's really not very constructive and actually probably relieved they resigned and may have an exit interview because that's what you choose to do as your policy, but it's not necessarily going to be very constructive.
No.
And it's not a legal requirement, it's just perhaps getting some feedback from somebody.
Oh, I agree. I think they can be really valuable, but sometimes frosty. Not working for me, obviously, just to be clear, everybody. Good.
I'm jumping in here because the theme is people matter. Mm. And I work with a lot of HR people over the years, 25 years plus. I've worked with a lot of HR, and I can really respect and appreciate everything that HR contracts and so on. The phrase I love is that a good contract of employment offers not only protection for a business but flexibility. And I'm sure that if people turn to their contracts of employment when furlough came on board, if they didn't see the term if they didn't see the term needs of the business, as it were, or flexibility on hours, that would have thrown up quite a lot. I'm sure you agree, Joanna, that companies were probably looking at that straight away with the situation that happened last 18 months ago. But I would like to say that it's about people matters. And I think small businesses, as they're growing, have every opportunity to develop the values and the cultures of their own business, and therefore how they like that to be amplified in the staff they're bringing in. I know you said, Dane, that is really important. So I think at the front end of when you're actually looking at hiring staff is really important. Have the right job spec, which HR can help you with. The advert is almost like the sales side, engaging with people. But anybody who interviews on your behalf or needs to ask the right questions, they need to be fair, consistent in your recruiting process and your interviewing process. And I do think the front end of when HR deal with even the offer, if you go and let a manager offer the job and the salary and everything without talking to HR first, you're in hot water. If there's anything said, it needs to be very process, best practice, fair and consistent. And if you can bring people on board with a good onboarding, again, with the help of HR, and a good probationary period that involves lots of meetings and updating, then you will have a great entrance for your employee, and it can save you a lot of money, you know, in terms of, you know, making sure your staff are right during that time, and not having so many issues, because people do matter, and they're always a candidate up until the point when they're an employee. So that's a really important time, is my feeling, because recruiting and recruitment is a massive part of HR. It's a specialist front side, but it is about the people aspect. And by the time the contracts have come in, you need to have recruited on skills, experience, and the right fit. If you don't, I think the rest can be, you know, it's just time consuming and wasting time, and a problem waiting to happen. I've heard my say, because I really strongly believe how important recruitment side, the front end, is in building a team.
Yeah,
I agree, Sarah.
I hope I get some agreement maybe from Gareth in the engagement of the company and the organisation you're talking about, especially SMEs who are like building their staff on a dream. You know, they're building that, and you've got to have that engagement at the front end, I think.
Yes, yeah, no, I agree. And for people who don't know, the reason all you guys are stuck with me is because Sarah got me into Signal. So you only have Sarah to blame.
But there was honesty there, wasn't there, Gareth? It was
damn it!
Yeah. You've got to be honest, and you've got to be open to with the people you're dealing with, and ask them the right questions, basically.
Yeah.
Candidates, really important.
I completely agree with you there, Sarah. It's a really, really valid point. Very valid point when you're thinking about recruiting.
Thank God you got Gareth in.
Ooh.
I think you're right.
I'll tell you what, I'd track him down anywhere now. I can't manage without him.
I was just going to say I agree with you, Sarah. And ultimately you're dealing with people, and you want, people talk about the fit, don't they? But it is important, and particularly within a smaller business that you're growing, you need to find somebody who kind of represents your brand. Dana, thinking about who's going to be flexible as well in terms of what you ask them to do, because often in a small business, there's, you've got a number of different roles that you're playing. And then you need to invest in them. You need to invest the time. It's no good saying 6 months down the line, well, they're not very good at this or that, if you haven't spoken to them for the last 6 months. And I do see that happening. But often because managers don't feel uncomfortable with having difficult conversations with people. That's a whole kind of issue in itself. People aren't easy to manage necessarily. Some are a dream, and others are a little bit more challenging. And the trick is not to stick your head in the sand.
Whenever I've recruited, especially now with my own business, the biggest thing I look for is culture.
Yeah.
Was maybe not necessarily before when I was recruiting for large organizations, but definitely now it's who can live and breathe my culture. And even when I work for the large organizations, the one thing I always do in the recruitment is I tell the employee what I'm like to work for. Mm-hmm. So they know sort of what to expect. So there's no surprises then when they understand, like, this is what I'm looking for, and this is what I'll accept, and this is what I won't accept. I always make sure that's in the recruitment, because then I can gauge whether I think that employee will be able to be managed or coached.
Yeah, I completely agree. And we all do what we do. I mean, I'm a solicitor. There are lots of solicitors out there. I don't say, well, we're solicitors. There are things that we bring to the table that I think make us slightly different to the next solicitor. So you're looking for people who reflect the way you do what you do, not just what you do. Yeah.
Good. Right. As anybody, will take one last question if anybody's got one. If not, it will be a wrap. Anybody else want to add something? Yes, Jo.
One more. Just, you mentioned employee handbook and things like that. Am I kind of caught between Dane's comment on the culture side of things? I think it's brilliant, Dane, you're quite right. I think the most important way of phrasing all of this is telling them how I work, what I expect, da, da, da. I love an employee handbook, but if I'm doing freelance, do I have any right to give them a handbook as such? I mean, it wouldn't be like pages and pages, but it could just be a little bit on the escape to our ethos, you know, what I'm trying to do, a little bit about the brand. Is that okay, even though I'm not committing to employment as such?
Of course, but what you're talking about there is distinguishing between, you know, the sort of discipline and grievance procedure I talked about, which is only relevant if they're an employee.
Right.
You might have, I've got clients who have office manuals, and the first section is all about, here we are, this is what we do, this is how we do it, these are the rules, we like you to be like this when you deliver our courses, or, you know, we're known for this, this is our culture, this is our unique selling point, this is why we're in this area, this is where, you know, your history, introducing to your business. That's distinct from the kind of more formal policies and procedures you would have if you had, you know, as well as if you were. This is a manual really about how you do what you do and your style and flair and interpretation.
I don't call it policies, but it's introductions and the way we work, kind of that feel.
Manual, or that's a bit boring.
Yeah.
I feel Dane might come up with something more creative.
I'll think of something. But yes, okay, that's great. I wondered if I was kind of, you know, wanting my cake and eat it, that sort of scenario again, like pushing the boundaries. But yes, I want to be able to, it's still important.
Well, you still have rules.
Yes.
You're going to have, you know, guidelines about how you do what you do, or where people will find things, how they'll contact you, what sort of courses, what your background is perhaps, you know, a bit about you and your passion, and, you know, art is a huge subject, isn't it? What sort of art, that sort of thing. So it's
lovely. Thank you.
Yeah, and I agree, because at the end of the day, they're representing your brand.
Exactly.
You know, so, you know, you don't want someone that's, you know, non-arty, swears at everyone all the time, and, you know, that's not going to be a true representation of your brand. No, I think completely 100% you should have, I say, a manual and or like a handbook. Does sound a bit boring, but you know, make it more creative. But yeah, no, I think it's something important, I think, to have in any business. If you're bringing someone on that's gonna have some representation of your brand, it's important to make sure, whether they're an employee or not, that they sort of adhere to how you want it to be run.
I think with coming out of COVID and dealing with any sort of public, if you're holding lessons or if we're meeting in public, there is a whole area now of how you work within COVID guidelines or behave, you know, one way in, one way out, hand washing. There's a good reason to protect your staff, but protect your customers in terms of you're giving over the message that you considered the health and safety side. I think that's quite an important area if you're dealing with these, you know, the meeting with the public again, if you've got classes and so on. There's a good reason. You can do it upbeat, but you can make sure that you've thought about it, and their well-being and health and safety is important to you, because it is important, isn't it? As all the hard work that's been done at Signal, you know. So
definitely there'll be rules around how people operate when they're attending a course. COVID restrictions.
Fantastic, thank you, big help.
Great. Well, thank you very much, Joanna. That was really, really informative. It was really good. Thank you. I really appreciate your time coming today. How can people contact you? Is it best to put it in the chat, or shall I send out your details? What's the best way to contact you if they wanted a follow-up call?
Send out my details if you want to.
We can do that.
And then if people want any information from me, or, you know, we offer half an hour's free advice to all clients, you know, people who have inquiries. So, you know, if you want to come and talk to me on a Zoom or
Brilliant.
in our office from a distance, or over the phone, whatever, you know.
Yeah.
That's
okay,
fine.
we'll send out, we'll get the contact details out. Thank you very much. That's very generous of you.
Thank you for listening. Well, thank you, everybody.
Thank you, Joanna.
Brilliant. Right. So that's the end of the Biz Hub session today. Thank you so much to everybody for coming along. It's been so lovely to see you all. It'll soon be in the flesh, hopefully. Don't forget, next week is the collaboration session, where we will have a workbook based on People Matter and taking extracts from talks, etc., where we're going to go into breakout rooms. I'm hoping Sarah and Gillian are going to be assisting us next week, as they're both in that sort of line and speciality, and go into breakout rooms and really sort of hash out where you are at and sort of collaborate with the fellow members of the group. So looking forward to that next week. Don't forget to book on. And thank you to Michelle. I know your camera's not on, but I'm not sure whether you're still there, but lovely to see you. And we will be in touch with regard to how you can join the Biz Hub. So thank you for coming along today, and we hope you've enjoyed your first session. Great, right, without any further ado, enjoy your weekend, everybody. Have some fun. It's soon going to be open on Monday, so yeah, enjoy, and we'll see you all next week. Thank you very much.
Bye, everyone.
Bye.
See you. Bye.
Bye.